I was the one when you needed the love. All the things that you wanted alone. I was the hell that you needed. Oh, I was the one when you needed the love. I was the one when you needed the love. All the things that you wanted alone. I was the hell that you needed.
Welcome back to BaldPolitiKs. This is the 8th of March 2017 edition. As you can probably see, I'm suffering from a little bit from a cold, but everything is pretty much okay. And on this show, we're focusing on miscarriages of justice, no country in particular, although we are speaking to Paul Mc Laughlin of MOJO, the Miscarriages of Justice Organisation, who are based in Scotland. So that is what Paul is going to be talking to us about on this show. And before we get to that, let's have a look at some of the significant happenings on this day, the 8th of March. In 1920, the Arab Kingdom of Syria, the first modern Arab state to come into existence, is established. In 1966, Nelson's Pillar in Dublin in Ireland is destroyed by a bomb. And in 2014, Malaysia Airlines Flight 370, carrying a total of 239 people, disappears en route from Kuala Lumpur to Beijing. And no particular significant political births on this date, so I haven't included any of those. So yeah, let's get on to the topic for this show. As I said, we're speaking to Paul Mc Laughlin of MOJO in Scotland, who deal with miscarriages of justice.
So, the Miscarriages of Justice Organisation was set up by Paddy Hill of the Birmingham 6. When Paddy was released from prison, obviously when he felt that he was leaving behind a number of people who he felt to be innocent. So he dedicated himself initially, this is what Paddy says, to spending a year on trying to support those that he'd left behind in prison and try to highlight their cases and try to bring a bit of notice to them. So that's turned into a journey that's never stopped for his release.
Right.
2001 he set up the organisation because he felt that the level of miscarriage of justice wasn't being addressed properly, and because he was doing it with support of other people but in an ad hoc manner, he felt that he needed to try and put an organisation together that would address all aspects of the issue, not just the issue of prison release, but aftercare, legal issues, try to get appeal lawyers, etc. in place, and he was trying to ensure that he was doing as much as he could. So 2001 set up down at the House of Parliament, and mainly working in England, working in English cases mainly initially. MOJO had a Birmingham office for a number of years, and then Paddy eventually moved to Scotland, where we're based at the moment. We're based in Glasgow, and we currently, although we offer support in England and Wales, from a practical point of view, we can't intervene in the cases as much as we can in the cases in Scotland. So currently in Scotland, we have an office. I'm a co-project manager, along with my colleague Cathy Malloy. We run the organisation on a day-to-day basis. Paddy is still obviously involved in a number of cases, although he isn't necessarily in the office day-to-day, but he's there to consult, and also he's still involved in a campaigning role.
So there's a number of different cases you get involved in. You said primarily in Scotland. I mean, what makes you guys get involved in a case or take on a case, and then what do you do if you take it on?
So what tends to happen is someone who has been convicted will write to us from prison, or a family member or a friend will write to us. We ask that the person themselves write to us directly, and what we're looking for, because the basis of the work that we do is looking at cases of factual innocence rather than just broadly miscarriages of justice. So it's cases that we believe where people are factually innocent and are serving 4 years or more. Simply, the reason we've got that sort of cut off for the time period is simply that we couldn't deal with the overwhelming amount of inquiries that we get. If you were to look at miscarriage of justice over the whole system, you would be dealing with thousands of cases. So, as it stands now, the organisation, we receive anywhere between 100 and 150 requests each year for support. When someone writes to us, we send an application form out and we ask the person to give us as much information as possible, and also try to get them to provide us with any case papers that are available, and try to get them to give us a narrative as to why they believe they've been wrongfully convicted. So to that end, once the application's in, currently what the process that we undertake, we work with law students from a number of universities in Glasgow. That includes Glasgow University, Strathclyde University, Caledonia University, and a couple others with the Glasgow area. So we mainly work with third and fourth year students, but we also have people who have qualified but aren't practicing as lawyers, that have law degrees but haven't entered into practice, or have went into other areas and decided later on to use the law degree again, and they bring that skill to us. So part of what we do is sit down as a team. The case would be allocated to one of the caseworkers, and they would then examine the information that's available. We would then obviously visit the person in prison to try and get them to give us an insight into what their case is. We're also there because we've got obviously got to be very careful. It's the old sort of belief that every single person that's went into prison will try and make a case for innocence. So obviously we're trying to assess the person, we're trying to assess the value of the information that they're giving us, and we're trying to come to a point where we can say that although we're never going to be in a position where we say to anybody, oh, you're totally innocent, or we believe you to be totally innocent. What we're saying is that we believe that there's a case for factual innocence can be made in the case, and we will then assist them in a variety of ways. Now, it may be that all MOJO can do is be a listening ear for somebody and a guide to somebody in the process that they're going through. So it may be that we're the only person that they've got to phone and just on a daily basis for prison say, this is what's happening in the case, this is what I'm trying to develop. And or we'll work with the solicitor, assisted solicitor, to do sort of basic investigation and groundwork and try to develop an appeal. Now, we are financed partially by the Scottish Government to carry out that process, and the finance that comes from them is to provide support to those who have an active appeal or an active application or are in the process of making an application to the Criminal Case Review Commission. Basically try any avenues that are available to try and develop the casework for someone. And
you mentioned you take on the case of people who you believe are factually innocent. Is there a difference between that then and a miscarriage of justice?
Well, a miscarriage of justice could be based on a technicality. I mean, you could look at a case where if you examine the evidence, all the evidence is pointing at guilt, but the judge might make a misdirection in that case, and that would result in a miscarriage of justice. And quite rightly, the person should be supported there and the conviction looked at, and hopefully the person would have that sorted out. But it's not what we're about. Again, what Paddy's initial view was try to give a voice to innocent people that were in the position that he was in.
So for people,
recognising innocent people and try to support the innocent people, because what Paddy spoke about as well and continues to speak about is an innocent person in prison carrying the weight of any number of convictions, murder, rape, paedophilia, any number of things. You can be wrongfully accused of anything and having to go through a category prison with the kind of things, that stigma, and you having necessarily any experience of being in prison or knowing how to deal with that. I mean, obviously, it's the guilty person's got to face all that as well, but even more so for an innocent person facing the weight of a system and not only having to serve the sentence, but try to find a way of explaining their innocence to those around them, those within the system, but also to try and then develop that to actually come to some point where their case will be heard properly, to try and assist them either to get a retrial or have the conviction overturned altogether.
Okay, so you said you get 100 to 150 per year. Is that 100 to 150 that you look at, or requests that you get?
We get 150 requests initially. we'll filter that down. Some straight away for initial examination won't meet the remit and won't meet the criteria, so they're sifted out very early on. It's then a prolonged process with the other cases to try and come to a conclusion. I mean, one of the difficulties is it's very often that you'll come across a case where you may believe that the person's factually innocent, but it's going to be extremely difficult to develop further evidence that will allow them to go back to the appeal court, because any appeal is obviously going to be based on new evidence being developed. So you can, well, we've found in a number of cases, because of the nature of how the person's trial went, that you can look at the evidence available in the trial and make a case for factual innocence based on the information there. But the problem being that there is no possibility really in some cases of developing further evidence, because there's very limited sources of evidence being initially used to convict the person, right? Which makes it quite difficult then to try and develop anything new. I'll give you an example of a case where we have a client who we do support and we believe to be factually innocent. He's convicted of murder, and what had happened was there was an altercation happened at a bar that he frequented, and a fight had developed on the evening of this particular incident. The fight had spilled out of the pub, and it resulted in somebody being stabbed to death. Now, our guy is convicted on the basis of eyewitness evidence, seeing a person and claiming that that person is our guy. What the difficulty is what had actually happened. Our guy's wearing a white tracksuit. He's come outside of the bar as the altercation's happening, and he's went to assist the person. He's seen the assault happening. What the witnesses have seen initially was a person in a white tracksuit attacking this man and then putting him on the floor. They've decided to leave their property and come down to assist the person that's being assaulted. But as they're coming down for their position where they viewed it initially, the person that had committed the assault has left the scene, and our guys come out the pub dressed quite similar, right, and approached the victim and tried to give assistance. Now, there is evidence there supporting that was what had happened, but on balance, when the trial had went ahead, these people were convinced that our guy was the person that had carried out the assault and didn't make any distinction. It even went to the point where we actually got the person who had carried out the assault. That person was recorded admitting his guilt and basically laying out, without his knowledge, right? He was sort of a bit of subterfuge was used to get him to talk about what had happened. So he detailed the crime, he detailed what had happened in the crime, and he exonerated our guy by simply, it was our guy actually got him to talk on tape. He's basically saying to him, no, everything will be sorted out, the truth will out, all the usual cliches. We took that evidence along with our client to the Crown and tried to use that as a basis of new evidence for the appeal, and it was rejected because basically what they're saying is well, the credibility of the person making the statement isn't very strong himself because he's got a record, right? So how do we know that he hasn't been coerced into making the statement? So it didn't have the value that anybody, well, I would suppose any right-thinking person would have given value to it, given the other circumstances and how they had been explained. So basically, although we'd attempted in that case to show new evidence, once we'd presented that and had it rejected, it was basically left in a situation where by any other avenue to turn. You can't turn the witnesses aren't going to change their position because they're genuinely saying, well, I think I've seen this, I think I've seen that person. They're only doing it out of malice, they're doing it out of misidentification, and no way having that information changed. Again, the failure to use, or the Crown to allow the evidence to go forward, it was presented as a confession evidence. There isn't another avenue. So although we can sit and look at the case overall and look at it as a whole, and for your position believe there's a case for factual innocence, it doesn't meet the criteria for what the appeal court's looking for.
Okay. Now, how widespread is it, do you think, people being sent to prison for something that they didn't do?
Well, there isn't great statistics on this, right? But the last statistics that were produced for England and Wales were in, I think, 2007, 2008. And it's the Lord Chamberlain's office that produced these figures. And what they'd said was that in capital cases, since the release of the Guildford 4, that there had been over 7,000 miscarriage of justice passed through the courts and upheld as miscarriage of justice where the conviction had been quashed. Right? So that's in cases of 4 years and above, that in a 20-year period there's been 7,000 cases.
Right. Okay, it's quite a high number. And has that changed? Has it changed or improved since even things like the CCRC or the Scottish version of the CCRC were introduced?
Well, I can only tell you that, the reason that the CCRC was set up was obviously to replace what had been in place previously, which was rough justice and trial by error and World in Action working on cases and investigative journalists trying to develop the cases themselves. So the Royal Commission that was undertaken after the Irish cases had been sort of the cause célèbre. The result, obviously, was the SCCRC. It was initially worked in a very good way. A number of cases had been passed through it, and a number of people had been released, and it kind of hit a peak in the sort of mid-90s. But they then changed the goalpost slightly, changed the nature of what cases could pass through, and from your point of view, it's kind of diminished over the years. They don't necessarily use the powers that are available to them to properly investigate the cases, or in fact, the length of time it takes to develop cases is pretty long and pretty it can be quite unsatisfactory for a lot of people. Gone by their own statistics, right? All the cases that have been heard by the CCRC and the SCCRC in Scotland, the SCCRC in Scotland have got a sort of higher hit rate of success, but only marginally. So it roughly works out that all the cases I've heard, only 3% of them result in the conviction being overturned. Now, what you've got to bear in mind, with that 3%, that includes everything from traffic offences up to murder, right? So you're very lucky if you are going through that process that you'll be successful in a capital case to have your conviction overturned in that route. I think the equivalent on the appeal court side of it, viewing the same type of cases, is there's a 5% success rate overall. So it's a very small margin to be successful. Okay, and in your experience, we'll probably leave it on this, what do you think is the main cause for it? Because technology is better, people can use DNA. Surely at this stage, and investigative journalists have set the pace, surely at this stage something like this shouldn't be happening anymore. I mean, why is this still happening, or what's the main cause? Well, I mean, it's pretty obvious. What is the common denominator in all these situations? Human beings. Unfortunately, where there's humans, there's errors. You're always going to have miscarriages of justice. The issue isn't the fact that you're going to have miscarriages of justice. It's how you deal with miscarriages of justice once you do realise and you accept that you're having them. So it's the failure to put mechanisms in place to, one, look at why miscarriages happen, how they continue to happen, because it can happen for a variety of reasons. It could be anything from defective representation to the classic scenario of actually being fitted up by the police, or there's a variety of reasons why somebody ends up being wrongfully convicted. What, for your position, the failure is to have any oversight that looks at the judicial system, that looks at the police, and ensures if a miscarriage happens, that some investigation's done into why it happened, and to try and then ensure that these same mistakes don't continually happen. So thanks very much to Paul Mc Laughlin of MOJO for his time, and if you want to know more about them, you can find out all about them on miscarriagesofjustice.org. So that's about it from us on this show. So from me, Peter Carney, until the next show, take care.
Love, I was the one when you needed love. The secret you wanted.